Hey, Okay, good afternoon, everybody. You're in First Appearance Magistrate Court. My name is Judge Kim Teresa Malika. Today you will be informed of the charges, and we're going to determine if they're probable cause. Today is not your trial day. Do not talk about the facts of your case. Everything's being recorded. You have the right to remain silent. We have, I don't know who's in the main jail today. I'm suspecting it's Mr. Romero in the main jail, and if you're not at the main jail, we have Mr. Reedy here in the courtroom. If you have a private attorney, please let me know when you step up to the podium. I know that we're waiting for two private attorneys on Martin Bulldog and there was another person, so we're not calling them first. I believe they told them to be here at 1:30. It is only 1:16, but we will call the first case. Is Trilexia Tasha La Leverett.
Ms. Leverett's here and President Main. She is approaching, Judge.
Okay.
Come on up.
Good afternoon, Ms. Leverett. How are you?
Good afternoon.
You have a trespass of a property, not a structure or conveyance. Does she want to resolve this case today?
Judge, as being Ms. Leverett, I do not think so. She has a clean record. I don't know if this type of offense should be eligible for some sort of diversion program where potentially the state would agree to dismiss the case. She's 19 years old. She's getting her GED. I'd ask you to consider an ROR, considering this is a nonviolent offense, a misdemeanor offense, and she really has no contact with the criminal justice system.
All right. I'll ROR her, and the court does find probable cause. Ma'am, is your address 618 11th Street?
Yes.
Is it northwest, southwest, anything like that?
No.
Just 618 11th Street, West Palm?
Yes.
All right. All right, look for your court date. You don't want to miss it. Thank you. Good luck to you. You're welcome.
Ms. Saint-Tima?
How many are there total? Do you have 7? Extradition forms signed? Is there 7 extradition forms signed? Okay. Just make sure on the number, because we had 8 people. But there were only 7. Okay, I'm sorry. Are you Tatiana Santima?
Yes, ma'am.
How are you today?
I'm good, and yourself?
Good. You have a trespass structure, not structure or conveyance. $25 bond. Does she want to resolve her case as well?
Similar to her, she has a clean record.
Good luck.
She's interested in maintaining her clean record, so she could be possibly a candidate for some sort of diversion program. I'd actually consider an ROR. She's also working on her GED, so that's what we're asking for, Judge.
Okay, 141 North Robbins Drive.
Yes, ma'am.
Okay, state any objection to ROR?
No.
Okay, ROR, ma'am, make sure that you look for your next court date. Okay, good luck to you.
Thank you.
Thank you.
Johnson, you're next. Come on up. Johnson.
Nathalia Renee Johnson. And then after that is Jeanette Perez.
She's here present, Judge?
Okay, ma'am, is this the same thing? Let's see. Trespass, occupied structure, or conveyance. The court does find probable cause.
Judge, Ms. Johnson is speaking to her. She is interested in resolving her case today. In exchange for a no contest plea, she's asking the court to consider giving her adjudication time served.
State, any objection?
One moment, Judge.
What's her priors?
That's what I'm checking right now. Trespass last year, resisting without violence 2014, criminal mischief 2014, theft 2014 with the VOP, battery 2010, theft and trespass 09.
Okay, adjudication time served. Court costs.
She wishes to accept that, Judge.
Okay, no return. State, you want to give me the address?
4039 Northwest 19th Street in Lauderhill.
Okay, does she agree no return? Mr. Romero?
Yes, Judge, she wishes to accept the state's offer, and she has no problem adhering by Your Honor's court order as far as no return, and she will be asking for 1 year to pay court costs, Judge.
Okay. Okay, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, is your name Nathalia Renee Johnson, Johnsson?
Yes, ma'am.
Okay, put your hand down. It's my understanding you wish to waive your right to a trial?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
You under the influence of any alcohol, drugs, or medication?
No, ma'am.
Okay, you want to plead no contest to trespassing, occupied structure, or conveyance?
Yes, ma'am.
Okay, the court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. Court's going to adjudicate you, time serve you, $293 in court costs, 1 year to pay. No return to the 4039 Northwest 19th Street, Lauderhill, Florida. Do you understand?
Yes, ma'am.
Okay, if you don't pay the court costs, they'll suspend your driver's license, put it on your credit report, and so forth. So make sure you, even if you make payments, you have 1 year to pay, okay?
Yes, ma'am.
Good luck to you. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Jeanette Perez, and then we have,
North Broward.
hello. Good. Which case are you here on? Okay, she's the next one that's up.
Yes, I'll step outside.
Absolutely, we'll put it on the side. Is this the one with the co-defendant, or?
Yes.
Who's the co-defendant?
Boldick.
Okay, I have it right
Yes,
here. Okay,
that guy.
take as much time as you need. Tell him to take his time, no problem. I'll wait for him, okay? Just make sure you tell him the room number. Okay, Jeanette Perez, you have resisting an officer or obstructing without violence, and count 2 is trespass property, not structure or conveyance. Court does find probable cause. There's a $100 bond set.
Your Honor, this court placed this defendant on pretrial supervision on the 9th of February in case 18-1626 CF10A, 1 count of possession of cocaine, 1 count of resisting without violence, 1 count of trespass, and 1 count of tampering with evidence. Based on this court's finding of probable cause today, we ask that her pretrial status be revoked at this time.
Okay, Mr. Reedy?
Well, Judge, I'd ask you not to revoke her pretrial release on that case. I'd ask you to leave the $100 bond in place. Let the division judge decide whether or not her pretrial release should be revoked.
Tell you what I don't like is she's telling the other co-defendant to defy the police officer.
Yes, Judge, I read that. And I also saw that she had been previously trespassed from that location. However, it's still a trespass, and the resisting is not a violent incident.
I understand.
Just to advise the court, her place of arrest for the case that you placed her on pretrial on is approximately in the same location as this offense. This occurred at 5433 North State Road 7 in Tamarack. The case she's on pretrial, her arrest location was 5317 North State Road 7.
All right, court's gonna leave her bond as is. Let the division judge deal with her pretrial status, okay? I'm not revoking it this time. You can, it's without prejudice.
Thank you, Judge.
Okay, that's fine.
Post bond, Ms. Perez. $100, okay?
Thank you. Julianne Perez. Julianne Fraser.
North Broward.
Okay, Ms. Fraser, you have 2 capias or 3 capias, $500,000 bond. You have 2 no bond holds. You are going before your division on March 9th, 2018 at 10 a.m. So she has 2 felonies. Otherwise, I asked her if she wanted to resolve her other 2. So we'll just leave the bonds as is. Thank you.
Thank you.
Wayne McDonald. And then we have
Mr. McDonald,
Thomas
your
Kelly
present, Judge
Hicks.
Maine.
Okay? Okay, sir, you're charged with trespassing, unoccupied structure, or conveyance. Court does, find probable cause.
Your
Anybody
Honor,
wanna-
I would argue there is no probable cause in this case. It appears as though Mr. Sesme is the one driving the vehicle. He's charged with grand theft auto. It appears Mr. McDonald is merely in the passenger seat. There's nothing to indicate in this probable cause that he acknowledged that the vehicle was stolen, that he participated in the stealing of the vehicle, or anything along those lines. I don't believe that there's any way to establish that he's trespassing just by his mere presence in a vehicle that, as far as we know, unbeknownst to him, was stolen.
Okay, state.
Your Honor, there is probable cause for trespass. The lack of information that Mr. Reed's talking about is why he wasn't charged with grand theft auto.
How is it trespassing
All right,
if
this
he's
is
a
what
mere
I'm doing.
passenger?
I understand. This is what the court's gonna do. Court is going to find probable cause. Court's gonna ROR him. Thank you, sir.
Judge, can you specify for me what it is in the probable cause affidavit that the court is using as a basis to find probable cause in this case?
Okay, we're on to the next case. I made my ruling.
Okay, I understand exactly what you're saying, Judge. Thank you.
Mr. Reedy, I'd appreciate if you could hold those comments to yourself. I'd like to maintain professionalism in my courtroom, and I expect it from everybody.
I understand that, Judge. All I was saying is I understand exactly
sir.
what your
We're on to the
rationale
next
is.
case. We're on to the next case, sir. Thomas
Mr.
Kelly
Martin
Kitts.
Bulldog is the next case?
I have Thomas Kelly Kitts.
Oh, okay, sorry. Mr. Thomas Kitts, come on up, please.
Okay, Mr. Kitts, you have a capious misdemeanor, $250. You're being held no bond on a capious felony. You are being held no bond. You have a hearing division, it looks like FP, Judge Michael Usan, on March 5th at 1:30 p.m. Thank you. George Peter.
Mr. George Peter, come on up, please.
And then
If
after
he has
that-
some family here on his behalf, Your Honor.
Okay, and then we have Robert Overman. Okay, ma'am, if you could put your bag on the seat, please. Okay, are you Mr. George Peters, sir?
Yes, ma'am.
Okay, I have someone present here in court. Can you state your name, ma'am?
My name is Rose Peter. I would like for you to postpone and see somebody else because there are two other people coming. They would like to attend.
Sure, no problem.
Thank you.
Okay, your name
Rose Peter.
and your relation to Mr. Peter?
I am the wife.
Okay. All right, so when they get here, we'll recall it and we'll wait for you, okay?
Okay. Thank you.
Robert Overman.
Mr. Overman is here present, Judge at Maine. He is approaching.
Okay, and then we have Brian Leonard Williams. Mr. Overman, you are charged with aggravated assault with a deadly weapon without intent to kill. And count 2 is resisting an officer, obstructing without violence. We're not going to set a bond on that, but we do need to talk about bond on count 1. Any objection to probable cause?
It's close to me, Judge. There's no indication of how far away Mr. Overman was from the alleged victim or whether he brandished the knife in a threatening way. There's a lot of conclusatory language by the officer in here that he intentionally and unlawfully threatened, but there's no mention of what threats were made. There's no mention of, again, the distance between the two of them. I think it's a very weak probable cause case. I think the court probably could find probable cause. But the weakness of the case, I would ask the court to take into consideration when determining what an appropriate bond should be for Mr. Overman.
It says he hold a knife with his right hand.
For all we know, he's left-handed, Judge.
Doesn't mean he can't use it with his other hand.
No, I know. I just think it's lacking in a lot of detail as to what the actual threat was, unless we know how close together they were, whether words were exchanged, anything along those lines to create this well-founded fear in Larry Morris. And I don't think Mr. Morris is ever quoted as saying in the probable cause affidavit that he was in fear. So there seems to be a paucity of of evidence to support the elements of an aggravated assault with a deadly weapon in this case.
Well, the officer did see him with a knife in his hand. Anyway, state.
Your Honor, Mr. Overman, last year he had a trespass in 1998. He was convicted of aggravated battery of a law enforcement officer, 2 counts of aggravated assault against a law enforcement officer, battery on a law enforcement officer, and resisting with violence. Based on his criminal history and the allegations in this case, I'd be requesting a $5,000 bond and no victim contact, no weapons, firearms, or ammunition until further order of the court.
Okay, defense.
Judge, in speaking with Mr. Overman, he's 52 years old. At this time, he's unemployed. He gets disability. He gets approximately $730 per month. Unfortunately, he is homeless. However, he gets his mail at the HACK program located in Fort Lauderdale. From what he advised me, there's no one that could potentially post his monetary bond, and he's not in a financial position to post his monetary bond. Judge, I do understand as far as what the state read off as far as his priors, but I wouldn't know if they were quite dated, Judge. In speaking with Mr. Overman, there's not going to be anybody that can post his bond, but he will come to court. He looks forward to addressing these allegations in court. I'd ask you to take into account what my colleague said as far as for mitigating circumstances, whether or not there was a well-founded, reasonable fear on behalf of the victim. I do not think so, Judge, so therefore I'd be asking for mitigation purposes to consider releasing Mr. Overman on standard pretrial release. Also, I'd ask you to sign a photo order so we can photograph Mr. Overman's injuries, Judge.
Your Honor, under the rules of criminal procedure, because of the one of the top count, he's not entitled to ROR to pretrial release supervision. Unless...
I thought it was with the photo order. Okay. Court will grant the photo order.
No, Your Honor, and I wasn't objecting to... that's what I knew the court was granting that. I just, before the court, I didn't want to wait till after.
All right, so you're asking for how much bond?
5,000.
Says at large. Where does he live?
He's homeless. He's homeless, Judge.
Does he have a mailing address? How's he supposed to get to court, I mean?
Address, what I said earlier, it would be at the HACK program in Fort Lauderdale.
Okay, give me the address.
920 Northwest 7th Avenue, Judge.
And that's where, Fort Lauderdale?
Fort Lauderdale, Florida. Do you know the zip code? 33311, Judge.
Okay, sir, you're to have no victim contact, direct or indirect, with the alleged victim with the initials LJM, who is Larry Morris. Do you understand, sir? That means through no third parties, social media, and the like.
Yes, sir.
Okay. And that means no telephoning, no in person. You see him, you walk the other way. Do you understand?
I understand, sir.
Okay. Court is going to have the clerk update your address to 920 Northwest 7th Ave, Fort Lauderdale, Florida, 33311. If you change your address, your mailing address, it's your responsibility to notify the clerk of court. The court is going to set a $1,000 bond. The court is going to put you on standard pretrial with you reporting 1 time a week and calling in 1 time per week. Thank you. Brian Leonard Williams.
Mr. Williams, come on up, please. Overman. Mr. Reedy, we're going to need a Spanish interpreter. I think I forgot to call you earlier.
Yeah, I think you might have.
Who is this for,
Yeah,
Hernandez?
I apologize. This is Mr. Williams, Judge.
That's all right. When you forget at the jail, when you're done at the jail, you can come over here and help Mr. Reedy. I'm joking with you. Ryan Leonard Williams. You're charged with 1 count of trafficking in heroin, 14 grams, less than 28 grams. Bond set at $250,000. Count 2, possession of cannabis, 20 grams or less. Driving while license is suspended, and possession of open container. The court's going to ROR on 3 and 4. 2 and 3. 4 is not for magistrate. The court does find probable cause, unless I'm going to hear an objection by the defense. And we need to talk about the $250,000 bond.
Your Honor, if the court's found probable cause, Mr. Williams is out on 2 separate felony cases out on bond, and they're both filed. 2017, possession of cocaine. He's also out on bond 2017, possession of cocaine with intent to sell or distribute.
Okay, what are those case numbers?
The possession of cocaine is 17-12941 CF10A. The possession of cocaine, and there's also a second count of possession of cannabis on that case, Your Honor. The possession of cocaine with intent is 17-10187 CF10A.
So it's 101, right?
Yes, ma'am.
Possession of marijuana is under 20 grams?
Yes, it's a misdemeanor.
Okay, well. All right, so you're asking for on count 1?
Your Honor, in light of his 2 pending felonies and the potential prison sentence he faces if convicted on this charge, I'm asking that the $250,000 bond be kept in place.
What did he bond out on the other charges?
The possession of cocaine with intent was $2,500. The possession of cocaine was $1,000.
Hey, defense. Judge, in reference to the case before you, and speaking of Mr. Williams, he's 38 years old, been here his whole entire life. He's works for a car wash. He's been working there for about 3 years. On a good day, depending on the amount of cars, he could get up to $120 per day. He lives in Fort Lauderdale. He shares an apartment with his roommate. He's been there for 3 years, and the rent is $900, which they split. His assets include, he owns a Toyota Corolla, 1999, with approximately 100,000 miles. He believes the resale value on the vehicle is about $2,000. He does have family that live in our community. Specifically, he's going to be trying to contact his father to help post his bond. Judge, bottom line is financially, him nor his family can come up with $250,000. That's tantamount to no bond on Mr. Williams' behalf. We'd ask you to consider reducing count 1 from $250,000 to $25,000 on Mr. Williams' behalf, Judge.
Okay, state.
Your Honor, he's out on 2 separate felonies, one of which is drug dealing. He's now before the court alleged to be in possession of over 25 grams of heroin. Additionally, he's been to prison before 2000, possession of cannabis with intent to sell. He was sentenced to just under 20 months state prison. 1999, possession of cocaine with intent to sell or distribute with a violation of probation, just under 20 months state prison. 98, possession of cocaine with intent to sell or distribute. That was under the name Brian Ware. Possession of cocaine with intent to sell or distribute, 98. He violated his probation. More recently, 05, possession of cocaine. 04, possession of cocaine. 06, possession of cocaine. VOP, 5-year state prison. Your Honor, he scored enough points that in 08, DWS habitual offender, sentenced to 30 months state prison.
Okay, court does find probable cause. Court's going to leave the bond at $250,000. And on count 1, count 2 and 3 is going to be ROR. Count 4, the possession of open container, is not for magistrate. I'm going to leave. I'm going to do a GPS level 2. If for some reason he does bond out, I don't know what's going to happen with these other cases, but the court is going to revoke his bond on case number 17-10187 CF10A, which is the possession of cocaine with intent to sell. based on the fact that the court did find probable cause for trafficking in heroin between 14 and less than 28 grams. Court's also going to revoke his bond in case number 17-12941 CF10A, which is a possession of cocaine charge, which is another case pending, without prejudice for him to go to his division judge, obviously. Good luck to you, sir. Next one's going to be Orlando, or we need to get a Spanish interpreter, so this one.
And
Just
Mr.
put
Sanchez, who
Spanish on
follows
there.
Mr. Mendez.
Yeah. Sanchez, I'm sorry, who?
Mr. Orlando Mendez and Mr. Julio Sanchez are going to require Spanish
Okay,
interpreters.
so both of these. All right, Randy Kelly Petit.
Mr. Petit, come on up, please.
Okay, Mr. Petit. Good afternoon, sir. You're charged with 1 count, possession of cocaine, bond set at $1,000. You have a capious misdemeanor, bond set at $500. You are being held no bond on a violation, 2 violations of probation. You are going before your division judge, Judge Andrew Siegel, on March 1st, 2018 at 8:30 a.m. That's Judge Andrew Siegel. And we're going to leave your bonds in place unless someone wants me to discuss bond.
Nothing
Not
from
at this time, Judge, considering
Okay.
he has a no bond hold.
All right, court does find probable cause. Thank you. Junior Polo Sesame,
I've been advised
Sesame.
he's a medical reset, Judge.
Judge, I believe the other folks from the family on Mr. Peter are present. No, not yet? Oh, never mind.
No?
Needs a little more time.
Okay. All right, Oscar Garcia.
North Broward, I believe, Judge.
Okay.
North Broward.
Okay, Mr. Garcia, how are you, sir?
Está bien.
Do you speak English?
No.
What do you speak, Spanish?
Sí.
Okay, so.
Let's wait for the Spanish interpreter.
Obviously. Okay. Hey, un momento, okay? Go have a seat. Lawrence Danny Lawton. That's it for my Spanish abilities, unfortunately. Where, Conti?
Yes.
Okay, are you Lawrence Danny Lawton?
Yes, Your Honor.
Okay, sir, you have 1 count of DUI, alcohol, or drugs, 4th or subsequent offense. We need to talk about setting bond. Any objection to probable cause?
I believe that the reason he's here is because it's going from a 4th to a 2nd.
It's a misdemeanor upgrade.
opposite.
Oh, it's the opposite way.
Yep, it's felony DUI enhanced level 6.
And, Your Honor, bond was originally set at 1,000, and even though it's been upfiled to a felony, I'm going to ask for the court at this time to leave it at 1,000. I believe the state.
Did he bond out?
No.
Okay.
And he has a refusal charge where the bond was set at 10,000, and he's got a no bond hold on a felony VOP for felony DUI. So I'm just, for today's purposes, asking the court to reset the bond at 1,000. If the ASA or PD should make a decision to seek modification based on change of circumstances, I would ask that be left to the division judge.
That's fine, Judge. He has to go in front of his division judge anyway.
Okay, so the court's going to find probable cause for DUI, alcohol, or drugs, 4th or subsequent offense. Court is going to set bond at $1,000. Okay, thank you very much, sir. Bond set at 1,000. Okay, are you Derek James Smith?
That's correct, Judge.
Sorry. Okay, Mr. Smith, you are charged with an ad charge, I believe this is. Change of charge?
I believe it's just a change of charge, Your Honor.
All right, thank you.
Your Honor, Mr. Smith's first appearance on these I believe they came before the court as ad charges. You had set a $2,500 bond, I believe based on the fact that Mr. Smith has a couple other burglary holds. Burglary charges were $2,500 bonds were set on those. He was actually arraigned by Judge McCarthy on this case yesterday. I'd be requesting that the court place the $2,500 bond back on him, noting that even though it's a change of charge, the court did find probable cause for burglary structure at the first appearance, and you wrote that in.
Okay, defense?
That's what it should be, Judge. Mr. Smith, do you have a public defender in front of Judge McCarthy or a private attorney?
Public defender, sir.
All right. All right, I'll let him know what happened here this afternoon, okay?
All right, thank you.
Okay, good luck.
Thank you.
Jared Lamar Clark.
I believe he's in Paul Ryan, Judge.
Okay. Yeah, definitely. Look at it now. Okay, are you Jared Lamar Clark, sir?
Yes, ma'am.
Okay, you have a burglary of unoccupied conveyance, thank you. Unarmed, is he the co-defendant, or?
No, Your Honor,
Oh, okay.
this is just a... It's just,
Coincidence?
Yeah, exactly. Your Honor, and I showed Mr. Reedy, I provided the court a copy of his original first appearance findings from Judge Lerner Wren. She crossed it was, I imagine it was booked in error or charged in error, the armed part, because she crossed out the armed and made it unarmed. She set a $3,000 bond. That's what we filed. He's scheduled for arraignment before Judge Merrigan on Thursday morning. So, Your Honor, I'd be requesting that the $3,000 bond be placed back on him, and he be allowed to see Judge Merrigan.
All right, it says, please add count 2, change of charge to the magistrate docket. So count 2 is count 1, that's what it says. Like to come look at my note? Look at it.
Sure.
And then go to page 1. I mean the top page.
There's only one count left.
You see how it says 1? I don't know why
Yeah,
they do that.
Your Honor, when he was first arrested, as you can see on the findings,
Yeah.
charge 1 was the burglary tools. So for booking reasons at the jail, charge 1 is always going to be the burglary tools. Charge 2 is the burg dwelling. Charge 3 is the cocaine. When the clerk's office creates a new findings based on the change of charge, they put it at 1 because it's the only charge remaining.
Okay, I see. All right. Because I know sometimes they continue it.
Yeah.
And I don't understand. I don't know. Maybe you can explain it to me later.
I don't-
Why they do sometimes the 1 and sometimes they continue it. All right, so the court is going to find probable cause. We need to talk about bond. It's $3,000. Any objection?
Well, Judge, it is a burglary of an unoccupied conveyance. Isn't the standard bond $1,000 on that?
Well, it was previously $3,000.
Right. But it looks like that's the only charge that's currently holding him. I'm looking at the information right now, and that's all that was filed.
Your Honor, I suspect one reason at least one reason it might have been set at $3,000 is Mr. Clark's history. In 2016, burglary of a structure, grand theft auto, and felony theft, he violated his probation. And then in a separate case in 2016, he had a grand theft auto and he violated his probation in that case. And, Your Honor, I also believe, considering he's going to be seeing Judge Merrigan in 2 days, well, not even 2 days, Thursday morning, I believe it'd be appropriate to leave the bond in place. And since he's been charged, essentially, while it's called a change of charge, he has been charged with the same offense that the court found probable cause for at his first appearance.
No, he does. She crossed out armed to unarmed. I don't know if you see it.
I did. I looked at that, Judge, yes.
All right, so the court's going to keep the $3,000 bond, and I'll put on here in big letters. Obviously, they can do it anyway without prejudice, okay?
Thank you, Judge.
You're welcome. Okay, next one is, I don't know if you need that, Madam Clerk, is Elio Baptiste. I'm sorry, Maine?
He's here at Maine, Judge. He's approaching.
Okay, 5. Okay, Mr. Baptiste, how are you today, sir?
Okay.
You've been doing better?
I could be better.
Okay. All right, well, sir, unfortunately, you have a violation of probation and you're going to be held no bond. But you do have a hearing date before Judge McCarthy, Barbara McCarthy, on March 1st, 2018. So that's on this Thursday at 8:30 a.m., sir. Okay? So you can talk to them about your bond at that time. Good luck to you, sir, okay?
Give me back the murder case. Yeah, here it is.
Okay, Samir Rashid. Okay,
Mr. Rashid is here present, Judge, at Maine.
Okay, Mr. Rashid. You are charged with premeditated murder, 1 count. You have the right to remain silent. Anything you say can and will be used against you. Bond currently is set at no bond. State, are you seeking a finding of proof evident presumption great?
Yes, Your Honor. Your Honor, I'd be asking that the defendant be held no bond upon the finding of proof evident or presumption great for first appearance purposes only. Relying upon the probable cause affidavit prepared by Detective Derek Corsini of the Lauderhill Police Department, relying upon East Oswego State. Just noting, Your Honor, the evidence that was obtained from witnesses, the physical evidence, noting specifically surveillance video footage that was taken of the actual murder itself, and statements made by Mr. Rashid.
Okay, defense.
We would object to the court making a finding of proof evident presumption great and holding Mr. Rashid without bond on this charge based on what's been presented to the court this afternoon, which is basically just a probable cause affidavit. No witnesses have been called, no physical evidence has been introduced. The state has a videotape of this incident. Certainly you would think if they wanted you to hold Mr. Rashid without bond, they would have bought that in for you to take a look at it to see if it says and shows what they say it says and shows. They'd failed to do that. There is potentially an argument of self-defense here. None of these witnesses saw what happened inside the store, only what happened in the parking lot. And I'd ask the court not to make a finding of proof evident presumption great, but to set bond for Mr. Rashid in this case.
Okay, Mr. Rashad, I have reviewed the probable cause affidavit filed in your case, and I find probable cause. I further find the proof of guilt to be evident, the presumption great. Therefore, sir, you're going to be held without bond until further order of the court. This order is without prejudice for you to file a motion to set bond with the assigned division judge and request a hearing under State v. Arthur. You're going to be held no bond, sir. Good luck to you.
Your Honor, at this time, we'd be invoking Mr. Rashid's Fifth Amendment right to remain silent. Would advise all law enforcement, including the Office of the State Attorney and any of the police departments under their control or jurisdiction, that they are to have no contact with Mr. Rashid under any set of circumstances without first contacting his attorney, whether that be a public defender or a private attorney.
Okay, so noted. Thank you.
And that'll be supplemented in writing shortly, Judge. Thank you.
Okay, thank you. Okay, and then we have Brandon Magruder.
Mr. Magruder is here present, Judge, at Maine.
Okay, Mr. Magruder, you also have a violation of probation in front of Judge McCarthy. You're going to go this Thursday, March 1st at 8:30 a.m. Pending that hearing, sir, you are also going to be held no bond. Good luck to you, okay?
No problem. Thank you so much.
You're welcome. Have a good day.
Since when do you wait on anybody else?
All right, anybody else ready?
That's your sciatica acting up.
Okay, Spanish interpreter?
Your Honor?
Yes?
I don't know if maybe you want to, maybe we can go through the second looks?
Huh?
Is the Spanish interpreter here?
Not yet.
Not yet.
Not yet? Okay.
The later you ask, the later they get here.
Hold on 1 second.
I apologize. Already.
I just can't let it go, Hector. I'm sorry.
You just threw a jab at me for that.
Okay, we're going through the docket. What do we do with Junior Polo Sesame?
Medical reset.
There you go. You're welcome. All right, second look docket. Let's see. This is Friday. Do we have another one? Did you
Yes, we have.
Craig?
I believe there's 4 people on the second look docket. 1 is in Conti and 3 are Maine, Judge.
let's do the Conti first.
That would be Jeffrey Peterson.
Okay, Mr. Peterson?
Yes, ma'am.
Hello, sir, how are you? All right, tell me what it is, because I don't have it in front of me.
It's, one moment, Your Honor.
Peterson.
It was treated as a retail theft plus 300 second or subsequent, but I think it really looks more like a, one moment, Judge. Yeah, I mean, more than likely, it's going. More than likely, it's going. I imagine if it gets filed, it'll get filed as either a grand theft or a felony theft. You said $1,000 bond. I imagine that's based on Mr. Peterson's criminal history. 2015, felony theft with a VOP, 257 days county jail. Theft 2013, theft 2006, delivery of cocaine and possession of cocaine with intent to sell or distribute at a near park, resisting a merchant in theft.
Where was this? What store?
One moment, Judge. Yeah. This was at a, yes, ma'am. And it looks like it would be more likely if.
Took off the shelf several pieces of merchandise worth $163. Put it down his pants and just walk past the.
And reviewing the PC, it looks like if it's filed, it would probably be more likely a felony theft than a, but, Your Honor, just so the court's aware, the most serious priors, while dated, they were in the, looks like the late 80s. Robbery, firearm, deadly weapon, 12 years state prison. Strong arm robbery, these 12 years. Robbery, firearm, deadly weapon, 12 years. Strong arm robbery, grand theft, 2.5 years. Burglary, dwelling, tampering the witness, 2.5 years. Burglary structure, 2.5 years.
All right, so you're asking that his bond stay at 1,000, defense?
Well, I was going to say, I really don't recall if the court, I mean, I know the court did go over, you know, if he, you know, has a residence and whatnot. I just don't remember what the answers were with regards to that.
Did you speak to him?
Not this
right.
afternoon, Judge,
Let me ask
no.
him a couple questions. Mr. Peterson?
Yes, ma'am.
Do you have, if I let you out of jail, do you have a place to live?
Yes, ma'am.
Where would you live?
1400 Northwest 2nd Avenue, apartment 8, with my sister.
It's the address on the booking sheet, Judge.
I remember he told me Northwest. I remember this case. Let me see. Go to, yes. Thank you. Go to, 1400 Northwest 2nd Ave, apartment
Yes,
A.
ma'am.
Okay. Okay, defense?
Judge, I'd ask you to put him on pretrial release, standard PTR. It's I mean, I'm not minimizing his prior record, but it's still
$168.
it's $168 worth of things out of Home Depot.
Okay, sir, are you gonna be working if you get out of jail? What are you gonna do?
Ma'am, I get disability, but I do work days. I can work days, but I can only work so much.
All right, court's gonna put you on standard pretrial release. This is what the court's gonna do. The court's gonna have you call in twice a week. If you don't call in, you're gonna get violated. It's almost like probation. It's called pretrial release, okay?
Yes,
So
ma'am.
you're gonna call in twice a week and you're gonna go there one time a month.
Yes.
I was gonna do a GPS monitor, but I'm not gonna do it in this case. If you violate your probation, your standard pretrial will be revoked, and I'm gonna set a bond of $2,500. Do you understand?
Yes, ma'am.
All right. All right, so standard pretrial. And sir, you also have to, you wanna tell him, Mr. Reedy, about reporting, since Mr. Romero's not there?
About report, yes, within 24 hours of your release, Mr. Peterson, you must report to pretrial release, which is down here in downtown Fort Lauderdale, across the street from the courthouse. They'll give you a map up there, but make sure that you report within 24 hours of getting out of jail. Otherwise, you'll be in violation, you'll be right back in jail. We don't want that, do we?
No, sir.
All right, so you know what to do, right?
Mr. Tracy,
Okay, do it.
is that fine? Do I
Okay,
put
good luck.
pretrial in there?
All right, thank you, Judge.
You wanna just write it? I'll see how you do it.
Judge, I think we're ready on the Peter case.
Okay, thank you, good luck to you, sir. Okay, so we're done with that. What is this, Peter?
The Peter case, yes, Judge.
Is there anybody else with him? Just himself, right?
Correct, Judge. He's that main judge?
No, I'll save that. Okay, all right, George Peter?
Yes, ma'am.
Okay, does his family want to step up over here? Okay, all right, would you like to say your names, please, and your relationship to Mr. Peter?
Peter, I am the wife.
Okay, if you could talk into the microphone,
I am was Peter. I am the wife.
thank you, and your name, sir?
I'm Jitu Zaveri. I'm a friend of his.
Okay, thank you.
My name is Chiranjeev Jariwala. I'm a good friend of his.
Okay, all right, thank you for coming today. All right, sir, you are charged with 2 counts of abuse of a child without great bodily harm. Any objection to probable cause?
It's always a fine line with government interference and how a person raises their child, but no, I don't have a probable cause argument to make. Based on that very low legal standard, I think the court can find probable cause.
The top one's from before. Okay, so the court does find probable cause. Let's talk about setting bond and any special restrictions. State?
Your Honor, I'm going to be requesting bonds in the amount of $2,500 per count. No contact with either of the alleged victims.
Okay, and the alleged victim's initials?
Your Honor, unfortunately, their initials are not listed. See if I can work on that. And, Your Honor, if you want to take testimony in the meantime, I can see if I can get that information.
Okay, clerk, can you swear them in? Yes, if you could swear them in, please, and have them state. Raise their right hand. It's okay. Okay, you have.
My last name is Peter, and the first name is Yvesrose.
Okay, is there anything you'd like to tell us, ma'am, with regard to the availability of affording any bond? $2,500 per count is what the state is asking, total of $5,000.
What do I say about the bond? I don't know.
Can you afford to pay a $5,000 bond, ma'am? You can?
Yes.
Okay. All right, they said they can afford to pay a $5,000 bond, the friends. Mr. Romero, anything further? Anything further, Mr. Reedy?
No, may I just have one moment?
Linder, no victim contact with either juvenile?
I'm just gonna,
Okay, no, I have nothing further to ask, Judge.
and Your Honor, what I'm gonna try to do, I would ask for the court to issue, a no victim contact order. It does appear, based on the allegations, that there is a family relationship between all three parties, and it would appear that they are both known to Mr. Peter. What I will try to do before the end of the docket is supplement the court file with the initials. And obviously, if I am able to obtain that,
Get them? I can get them, if you want me to. All right, I'll let you do it.
Sounds like they're twins, 13-year-old female,
no,
13.
I
They're
think
they're cousins, I
yeah.
think.
Oh, male.
Yeah,
All right, well, obviously, I can't ask him, but if he wants to establish that he knows who the alleged victims are in this case, the male and female.
I'd rather
to
he
me,
made
that
no
would
comments
suffice.
about that.
All right, well, if you want to make the representation.
I,
Somebody.
if there's any truth at all to the probable cause affidavit, Mr. Peter knows who they are and who to stay away from.
Okay, good. All right, sir, so there's no contact, direct or indirect, with either juvenile. That means no in-person, no texting, no contacting them through third parties or anything like that. No social media, no liking anything on Facebook, Instagram, anything like that. Do you understand, sir?
Yes.
Okay, this is without prejudice for you to go before your division judge.
Judge,
And-
one moment, I just wanna see if Mr. Peter wants me to make one request of the court. I just wanna ask him, okay?
Mm-hmm.
Judge, this is a situation, this is what Mr. Peters asking me to ask the court. I believe when you asked, he had very, very good friends that are here in support of him.
Yes.
And I know because of their friendship, because of their loyalty, they didn't hesitate for one moment telling the court that they would post his monetary bond. And speaking with Mr. Peter, I know legally they're not responsible. He wants to try and have his wife pay. He's a teacher. She's right now with the bills, with the mortgage, things are tight. He wants to be financially responsible for this because it's him that got arrested. He appreciates his friends, their support, but he's asking, Your Honor, if you would consider reducing the bond to $1,000 each count. Therefore, I believe him and his wife could go ahead and post his monetary bond. As my colleague argued, Judge, I asked you to take into account, I believe Mr. Lender may have said this is his first contact with the criminal justice system. He's a teacher. He's been here, living here for over 20 years. He's not a flight risk. He's looking forward to his day in court to contest these allegations. Judge, having said that, I'd be asking you at this time, considering his first arrest, he's a registered voter here in Broward County. He's a teacher. Would you consider lowering the bond on count 1 and 2 to $1,000 each count?
Respectfully, your request is denied, $2,500 each count. I know one alleged victim's initials are YRP.
thank you, Judge, I didn't see that.
There's only one victim notification.
Oh, Your Honor, that's, I believe that's a contact person for them. They usually, when there's juveniles,
I
they put in
see.
adults.
Says 2 juvie victims, same next to Ken. All right, so I'll take that out. All right, that's what it is, 2,500, no victim contact with either juvenile. Thank you, sir. Good luck to you.
Yes, Judge.
Good luck.
And Your Honor, our Spanish interpreter is present.
Okay, one moment. Okay, it looks good. No, we had to call up, Conti was very blurred, so we called up our camera person.
Your Honor, our Spanish interpreter is here.
Okay, Mr. Spanish interpreter, how are you,
Mr.
sir?
Mendez, Señor Mendez, ven aquí, por favor. I think the Spanish interpreter arrived, Judge.
Good morning. Good afternoon. Sorry about that.
Okay, raise your right hand. Do you swear and/or affirm to translate from Spanish to English, English to Spanish?
I do. Martin Vidal, the IDAUD, court interpreters.
Okay. Oscar Garcia?
Oscar Garcia.
No, Orlando Mendez Hernandez, Judge.
They're both on the docket, Hector. She's calling.
Hector wants to get out of there, that's what it is.
Yeah, well.
Oh, okay.
All right. Orlando Mendez Hernandez.
Oh, yes, Mr. Orlando Mendez.
Okay, sir, you're charged with 1 count of possession of cocaine.
De acuerdo, señora. Esto se le acusa de un cargo de posesión de cocaína.
Bond set at $1,000.
Ahí la fianza se la fijan a $1,000.
Court does find probable cause.
El juez falla de que hay motivo fundado para el cargo.
Anybody want to be heard with regard to bond?
¿Alguien quiere decir algo en cuanto a la fianza?
Judge, and speaking with Mr. Mendez, he's been residing here since 2002.
Después de,
32 years.
después de haber hablado con el señor Méndez, él lleva aquí residiendo desde el 2002. Tiene 32 años de edad.
He works and lives here in Broward County.
Trabaja y vive aquí en el condado de Broward.
Specifically, he's in construction. He's been doing that for 5 years now.
Específicamente trabaja en construcción, donde lleva haciendo los 5 años ya.
He lives in Pompano. He's been residing in the trailer with his roommates for 2 years now.
Él reside en Pompano, donde ha vivido en un trailer con sus compañeros de cuarto por ya 2 años.
My understanding, this is his first arrest ever, and he's a U.S. resident, Judge.
Según entiendo yo, es el primer arresto que ha tenido en su vida y es un ciudadano de los Estados Unidos.
It says he was born in El Salvador.
Dice,
U.S. resident, Judge.
Okay, U.S. resident, I stand corrected. Go ahead.
dice que nació en
He
Salvador.
has a green card.
Es residente, o sea que tiene tarjeta verde, residente.
Judge, my understanding is when he was arrested, he didn't have his phone with him, so he can't contact his roommates to post his monetary bond.
Su señoría, según entiendo yo, cuando lo arrestaron, él no tenía el teléfono encima, por lo tanto no puede ponerse en contacto con su compañero de cuarto para poder conseguir que le preste la fianza.
Judge, we'd ask you to consider placing Mr. Mendez Hernandez on pretrial release, considering this is a non-violent offense and this is his first arrest ever.
Señoría, nosotros lo que hemos pedido que considere poner al señor Méndez Hernández bajo libertad, bajo servicio de santo juicio, ya que ese es su primer delito y no es uno de ende violento.
Any objection, State?
No, Judge.
¿Hay objeción por parte de la Fiscalía? No, juez.
Okay, ROR, standard pretrial release. Let me just check his address.
De acuerdo. Sale bajo palabra de juramento.
1784 Southwest 8th Drive.
Sale bajo palabra de juramento con las pautas estándares de servicios ante juicio. Quiero simplemente cerciorar que la dirección de él es el 1784 Southwest Calle 8.
Pompano 330.
Okay, check that address.
Yes, Pompano 33.
Because I have another address of 3254.
Porque tengo otra dirección de 3254.
No, eso es viejo, donde vivía antes.
No, that's the old one where I used to live.
Okay.
De acuerdo.
Okay, 1784 Southwest 8th Drive, Pompano Beach, Florida.
De acuerdo, 1784 de la Southwest 8 Drive, Pompano Beach, Florida,
33060.
33060.
Sí.
Yes.
Okay, I'm having the clerk update his address. Mr. Romero, if you could explain to him,
De acuerdo, le voy a pedir al actuario de
changes his address.
que actualice su dirección. Explíquele, señor Romero, qué es lo que sucede si cambia su dirección.
Okay, we're gonna call Oscar Garcia. Is he a Conti? Oh, North Broward, sorry. Okay, good afternoon. Are you Oscar Garcia?
De acuerdo, buenas tardes. ¿Es usted Oscar García?
Sí.
Yes.
Okay, sir, you're charged with one count, attempted burglary, damage to structure or dwelling.
De acuerdo, señora. Usted se le acusa de un cargo de intento al escalamiento de morada con daño a la propiedad o del inmueble.
This is actually a change of charge to an attempt
Esto
at burglary.
Esto es un cargo que ha sido cambiado a intento a escalamiento de morada.
State.
Fiscal.
I'm sorry. This is actually filed November 28th of last year.
Señoría, eso de hecho fue archivado el 28 de noviembre del año pasado.
He's been arraigned by Judge Colra.
Thanks.
La juez Colrad ya le hizo la lectura de cargos a él.
He had a calendar call last Friday,
Tuvo una audiencia calendario para el viernes pasado.
and he actually has a motion to reduce bond scheduled for Thursday morning before Judge Colra.
Y de hecho, para el jueves en la mañana, él tiene una petición programada para reducir la fianza frente al juez Colra.
881. Okay, bond was set at 1,000 initially.
Yes, and I'm asking because of that, because he has a hearing Thursday morning before Judge Colra to determine a bond reduction, I'm asking the court to set the bond back at $1,000.
Sí, él tiene una fianza de $1,000. Sí, debido al hecho que el jueves por la mañana él tiene una audiencia de reducción de fianza frente al juez Colra, yo quiero pedir que vuelva a fijar la fianza a los $1,000.
Frankly, I don't know why a change of charge is coming through when an information was filed the end of November.
Sinceramente, no sé por qué es que están tratando de hacer un cambio de cargo cuando se archivó un documento acusatorio con el original.
If you go down to March 1st,
Aquí yo no tengo una audiencia una audiencia de petición. Si se fijan el 1 de marzo,
Motion to set bond.
Your Honor, I'll here.
yo veo que hay una
You don't have to
audiencia.
print it out. You're just saying it's March 1st.
Yeah, it's March 1st
No
at
tiene que
8:30
imprimirlo.
a.m.
Okay, so Mr. Reedy, I'm inclined
Señor
to,
Reedy,
since there's a
estoy
motion to
dispuesta.
reduce bond.
I agree, Judge. I can confirm in looking at our notes on the file, he does have a hearing set for 8:30 in the morning on March 1st.
Entonces, mira,
And that's for bond.
yo puedo cerciorar que sí, dado, fijándome en los apuntes, que él tiene una audiencia fija para las 8:30 de la mañana, fija para fijar la fianza.
And I would be, I just think we should let it go, Judge, based on other factors as well.
Y basado en eso y otros factores, creemos nosotros que deberíamos simplemente dejarlo ser.
Okay, thank you very much. We're
acuerdo.
gonna keep the bond at 1,000.
Muchas gracias. La fianza permanecerá a los 1,000.
Oh, pretty cool. I see what you're looking at now. All right, Julio Sanchez.
He's here present, Judge at Maine.
Okay. Mr. Sanchez, how are you?
Señor Sánchez, ¿cómo se encuentra?
Bien.
Well,
Okay, Mr. Sanchez, count one, you're charged with possession of cocaine, $1,000 bond. You have 2 capious misdemeanors. One has a $500 bond.
de acuerdo, señor Sánchez. Usted tiene el primer cargo, posesión de cocaína,
And that is
con
for
una fianza de
suspended driver's
$1,000.
license.
Tiene también 2 órdenes de arresto
Total
que no
bond
han
is
sido
1,500.
por delitos menores. La primera es de 500 y la segunda, Your Honor, may the interpreter ask for repetition regarding the second capious?
Yeah, it's a driving while license is suspended and temporary tag violation.
es por haber conducido mientras que la licencia estaba suspendida y no tener las chapas adecuadas.
Judge, in speaking with Mr. Sanchez, we'd be requesting a phone order so we can access his phone contacts to post, to get his friend's number, and he said his friend will be able to post his monetary bond.
Okay, at 1500?
That is correct, Judge.
Okay, thank you very much.
De acuerdo. Y, señor jueza, después de haber hablado con el señor Sánchez, me ha dicho de que quiere una orden del teléfono para poder ponerse en contacto con sus amistades, quienes van a poder prestar la fianza, la de 1500. Así es, muy bien.
All right, thank you very much.
Muchas gracias.
Any other Spanish cases? Anybody else need a Spanish interpreter? Mr. Romero? Anybody else?
Here at Maine, Judge.
Okay, anybody at North Broward need a Spanish interpreter? Anybody at Conti? Spanish interpreter. Anybody at Paul Ryan need a Spanish interpreter? Okay, we're back to the main jail. Thank you so much, sir.
Thank you, Judge.
All right, Nicholas Yant.
Here present, Judge.
Okay, Mr. Yant. State.
One moment, Judge. I just need to look at the allegations.
Mr. Yant was released pending pretrial verification on the 23rd of February. After speaking with him, we found out that he was supposed to be going to the primary purpose sober house. We were able to speak with them today and verify that there is a bed for him. What we're going to ask the court to do is to sign an order so that the defendant can only be released to a primary purpose sober house, one of their representatives or designees. He will be residing at 2458 Southwest 42nd Avenue, Unit 1, and we did speak with them, and they have agreed to come and pick him up.
Okay.
So
Any objection, defense?
in a condition, he has to resign.
Is that what you want, Mr. Yount?
Yes, it is.
No objection.
Okay, thank you. So ordered. Next person is Evan Wilson.
Mr. Wilson, come on up, please.
It was only like. This is easy.
Need to pull up this case?
How is this guy?
Hey, drug paraphernalia possession, Mr. Linder.
Yeah, I'm just checking to see if, oh, okay. Yeah, he has priors. If he wants to resolve it, the state's offer to be time served.
He wishes to accept the state's offer, Judge.
Okay, who is this on? This says assault on a law enforcement officer.
That was the last case. That's what he was charged with.
Okay, so I'm not signing anything for this then.
Well, I don't know what this is.
There was an order pending verification. We're gonna process that through today.
Okay, then I don't need this, Madam Clerk. Thank you. That was a plea form. Okay. So what are we doing with this?
I'd offered it time served.
State made an offer of time, sir. He wishes to accept the state's offer, Judge.
Time to pay?
One year, Judge.
Okay, sir, raise your right hand. Do you swear and/or, sir? You swear and/or affirm to tell the truth?
Yes, ma'am.
Your name, put your hand down, is Evan Wilson, W-I-L-S-O-N.
Yes, ma'am.
It's my understanding you want to plead guilty or no contest, to possession of drug paraphernalia?
Yes, Your Honor.
Okay, you want to waive your right to a trial? Give up your right to a trial. You want to plead no contest? Okay, anybody forcing you to do this?
No.
Under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No.
Okay, the court is going to adjudicate your time, serve you $293 fine, court cost. The court will give you 1 year to pay. Mr. Romero will tell you what happens if you don't pay. You get your license suspended, and then you get caught driving, and then you get thrown in jail again, okay?
Yes, ma'am.
Good luck to you. You have 30 days to appeal the sentence of the court. You're done with this case, okay? Okay, Jonathan Morose, M-A-R-O-I-S.
He's here.
Okay, let's see.
Good afternoon, Your Honor.
Good afternoon. How are you, sir?
I'm incarcerated.
I know. I don't blame you.
Your Honor,
You
this
have
is,
trespass, occupied structure. What are we doing with this?
it's a trespass and disorderly intoxication. I know they have, two trespasses there.
Does he
Your
want to
Honor,
resolve it or no?
If he does, I have an offer. The offer would be adjudication time served on both counts, Your Honor, and no return to the Flanagans.
No return to where?
Flanagan's at 1479 East Commercial Boulevard in Fort Lauderdale.
Okay, is that what you want to do, sir?
Absolutely.
But I don't want you pleading out just because you can't bond out of jail.
I don't care either way. I just want out.
Okay. What's his bond set at?
$25.
25.
Okay, sir, this is your choice. I can either adjudicate your time, serve you. It says 1 and 2, trespassing occupied structure.
That's what it says. It's trespass on one count, disorderly intoxication.
Okay, I'm just making sure. All right, so if you want to plead no contest today, the court will adjudicate your time, serve you. No return to Flanagan's. I'll have to impose $293 in court costs and give you as much time as you need to pay up to 1 year. Or I can ROR you.
Pardon?
Or I can ROR you, and you're gonna have to come back to court, though.
No, I'll just take it.
Okay, because I don't want you pleading out if you can't, just because you can't bond out.
Don't matter.
Okay, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
State your first and last name, spell your last name. Put your hand down.
My name's Jonathan Maroy. My last name's Maroys.
Okay, it's my understanding you wish to waive your right to a trial, sir?
Yes, I do.
Anybody forcing you to do this?
No.
Under the influence of any drugs, alcohol, or medication?
Oh, I wish.
Yeah. I ever
Not at the moment.
been treated for a mental illness, sir?
No. Hell no.
Okay, understanding what I just explained to you. Pleading guilty or no contest to trespass, occupied structure, and disorderly conduct, sir? No contest?
Yes. Does
Okay.
that mean that's only that one Flanagan's or what?
Yeah, you're gonna plead no contest?
Yeah.
Okay, the court's gonna accept your plea, find that's freely and voluntarily entered, court's reviewed the court file and finds probable cause for the plea. Court's gonna adjudicate your time, serve you, $293 in court costs, 1 year to pay. You are not to return to the Flanagans at 1479 East Commercial Boulevard. Thank you, sir, good luck to you, you're done.
Good luck, sir.
Okay? You're welcome.
Good luck, sir.
All right, who do we have left?
Judge, we have the two individuals from this morning docket that are
Okay.
their private attorneys.
All right. Can I get rid of this mess here? Is everybody through on my desk?
Slow
Hold on.
I have Darlene Engel, Judge. She's the
Sarah,
female.
come on up. There's your private attorney.
Hey, Darlene.
Okay, Nicholas Yant, this is what I was just asking you. Just give me 1 minute, gentlemen. You can stay there.
I think Mr. Reedy went to the bathroom.
stepped out, Judge.
Mr. Reedy went to the restroom.
Okay. What do we do with
Regarding
Nicholas
Mr.
Yant?
He's the one that.
He's the gentleman that you,
Order, Your
I
Honor,
believe,
and he's
pre-trial.
going to be placed on pretrial supervision.
Okay, so Madam Clerk, he was placed on pretrial. He didn't admit to these charges. Do you want me to give this to, what am I doing with this? Yes. Okay. Was there someone else that we did a plea on? Let me see. That you,
We did a
I
plea
need to,
on Mr. Evan Wilson, Judge.
did I sign Evan Wilson? That's the one, I did a plea on Evan Wilson, and I just signed Jonathan Morose.
Correct.
Okay, does anybody have paperwork on Evan Wilson?
I do not.
Well, I know you don't. Thank you,
You said
though.
anyone, so
I know, I
I'm
know.
responding, Judge.
I'm talking about the paperwork when you accept a plea.
Exactly, I don't have that.
All right, so can we make up paperwork? Here's what I did. You can read my notes. Okay. Just wanted to make sure we had it right. Okay, where do we put, Madam Clerk? I just want to make sure he's not held up in the jail. Where do we put time served on this? Do we have it? Does anybody know? Time served? Because I don't see it checked off, because I gave him adjudicating and time served on Wilson. Same thing on, is it checked off on Jonathan Morose? I just want to make sure they don't get held up. Just credit for time served. Just put time served, 1 day. Do we need to put anything in particular? I just don't want them. Huh? Well, how is she supposed to know unless we tell her just 1 day?
The clerk of court has access to that information, Your
Okay,
Honor.
I just want to make sure these two gentlemen don't get hung up off of time served. All right, so let's do Darlene Engel and Martin Baldick. Thank you for your patience.
Good afternoon, Your Honor. Jonathan Friedman, I'm here on behalf of Darlene Engel.
Okay,
Judge, this is initial appearance. There is a bond set. I've been speaking with Ms. Rodriguez from the State Attorney's Office. There's a nebia requirement as well, and I believe that Ms. Rodriguez is accepting what I've provided her in terms of the source of the funds for the premium from the bond, for the bond. So I think we're both stipulating that the nebia has been satisfied. The only thing that's outstanding is the prosecutor is looking for an affidavit from my client's brother, who is the one who's providing the premium. So we will supplement that, and if I could have 48 hours to get that to the court. But in the meantime, I have my client released. The bondsman will post the bond today.
That's correct, Judge. He did provide some documentation that I was able to review briefly. So I am satisfied with that for posting the $7,000 premium, that is acceptable to the state. I know it does reference collateral requirement, and I think the bondsman's going to take care of any other paperwork. It also says that the defendant is to surrender her passport.
We'll do that as well, Judge, within 48
all right,
hours.
so why don't we just incorporate the requirements? I can't tell which judges, is this Mike Orlando?
Yes, Judge.
Okay, we'll just incorporate their requirements and say the nebia requirement and collateral has been met upon the filing of an affidavit by the defendant's brother within, we'll give a time certain.
I think what they're asking for is that, because they did show me that a sizable amount of cash was taken out as a loan, so I guess they're ready to, essentially cut the check to the bondsman for the amount of the premium, which is $7,000. And what I was asking for was an affidavit basically indicating that he's not expecting these funds to get paid back, that it's essentially being gifted to his client.
All right, well, let me start with this. Can everybody announce their appearance for the record?
Sure, Elizabeth Rodriguez on behalf of the state.
I've already done it, but I'll do it again. Jonathan Friedman on behalf of Ms. Engel.
Okay, ma'am, are you Miss Engel?
Yes, ma'am.
Okay, ma'am, you're charged with obtained property over $50,000 by fraud. Bond is set at $10,000. Criminal attempt, solicit, conspire, first degree felony, $10,000. Count 3, criminal attempt, solicit, conspire, first degree felony. Bond is set at $50,000. So you're telling me, sir, that you have no objection to the $70,000 in bond?
Oh.
Okay, perfect. All right, and then the only thing that she can't do is travel outside of Broward, Dade, Palm Beach without prior approval of the court. She will be monitored by Broward Pretrial Services, Level 2 with the GPS. She will not go to any airport, seaport, interstate bus terminal, or interstate rail terminal. Interstate rail terminal without at least 24 hours notice to supervise release. She shall not possess or nor reapply for any passport. She will not possess any firearms. What are we doing with the nebia and the collateral? Can you just, so the nebia
So the nebia requirement has been satisfied, yes, Judge. And what'll happen is he will have 48 hours to have his client's brother, who I think the one providing the funds, provide an affidavit that's acceptable to the state, indicating a few things that we discussed off the record. If that doesn't happen, then that may be a basis for his client to come back into custody. So I'm sure we'll get it within that 48 hours.
the bondsman posts the bond this afternoon or this evening, Miss Engel will be released. That's our agreement, so.
Hey, I'm just writing this down, so if you could bear with me, because
Sure,
I
Judge.
just want to make sure.
She should have passport. She's been traveling outside of the country regularly. Right. And I'm sure that'll have to happen. Did they confiscate her passport when they arrested her? She must have had it. I mean, if she was at the airport, right? Okay, so it has to be provided to the clerk's. I mean, I can ask. I just don't know that I'm going to get
Okay,
an
you
answer.
said defendant's brother.
Correct. And the name provided was a Mr. Griffin. Was it Darren?
Darren Griffin.
Darren Griffin.
Okay, defendant's brother to file affidavit with clerk. So I guess you can just file it on the portal, so you have a
Yeah.
date and time stamp.
I'll do that.
Okay, defendant's brother to file affidavit with clerk.
And just one question, Darlene, did they take your passport when you got arrested?
No, sir.
Is that at home?
No, it's not. It's locked in the car at the airport.
Wow.
All right, so we'll have her surrender that within 48 hours too. I mean, that's reasonable.
Yeah, when you get out,
That's
you'll have to
fine.
go get it and
GPS
get
on
it to
her, I
me.
mean.
Exactly.
Yeah.
Yes, sir.
So let me just ask you this, because I just want to do the language here. Defendant's brother to file affidavit with
Assuming
clerk
she will, right?
via the e-portal
Do you have blank order form?
that says what?
That he is providing the premium for the bond and that he is not being reimbursed by any other party for doing
The
so.
premium of bond. Give me the language, sir. The premium of bond
He's not being reimbursed for the premium of the bond
is not being reversed. I was
By-
writing it backwards. Is not being, because I wrote the other one first. Is not being reimbursed
for the premium of the bond by any other party.
Okay, I don't like 48 hours, so give me a date and time. Want to do Friday?
About Friday, Judge.
Or no, before March, is it 2nd?
I was gonna say by 5 p.m., maybe March 1st, which is actually Thursday, which is closer to actual 48 hours.
All right, why don't I just do, because I wrote in March 2nd already,
Okay.
at 11 a.m. And then I'll write C, defendant to surrender. And she has access to this car, right?
You have access to your car? Well, Martin, the co-defendant, does, but
I mean, I'm sure they have a second key. If she's being released, they cohabitate. I'm sure
you have a
there's
second
that she
key?
Yeah, at the house.
Okay,
Yeah.
At the house with
all
her.
right.
So she can go to the house, she can get the key, and have,
And you'll bring the passport to my office, okay?
Yes, sir.
All right.
Okay, defendant to surrender passport
Excuse me,
to clerk, yes.
is the attorney writing a short order indicating that the passport is to be surrendered at that day and time and that the narrator has been satisfied?
I actually have it on here that I'm signing.
Yeah, typically they write a short order.
yeah, because that's a
All right,
lot.
then he can take my order and he can rewrite it, but I have it on here as well, okay? Defendant to surrender passport to clerk of court. On or before March 2nd, 2018.
Is there a judge assigned to this case yet, Judge? Because I don't see a case number on the court, on the clerk of court site.
You'd have to ask the state, I wouldn't know that.
Actually, we don't know that. The clerk generates the case number and the judge assignment. So I don't know if your in-court clerk has access to that, but. Okay. And give you the number for the arrest affidavit, but that's the only number
Okay,
that
so
there's
I'll
to
tell you what,
reference.
I am gonna give this to you, sir, but you need to put that, might wanna speak to, the lady over here on the end, the far end over there, and see what specific language she needs so that your client's released and there's no passport requirement. We have blank orders too, sir. If you could give them a blank order. Okay, great. All right, good luck to you, ma'am.
Thank you, Your Honor.
You're welcome. Martin?
In reference to Martin Bolduc, which is the remaining co-defendant, I discussed with the attorney that at this point I'm not willing to agree to any alterations of the bond conditions. That does not foreclose us from coming to some kind of an agreement. I'm waiting for for the defense counsel to provide me some documentation in terms of the home and some other assets that his client may have before I agree to any modifications of the bond.
Your Honor, good afternoon. Scott Sky on behalf of the defendant.
Hi.
Judge, that is accurate. I am hopeful that we can come to an agreement amongst the parties as it relates to our bond, although we're in a slightly different position than the prior defendant. Would the court consider resetting this matter on Your Honor's docket perhaps for Friday to give me?
Well, actually, I was
All
going to
right,
say.
well, let me do this. Just give me a moment, folks, because I want to
Sure.
make sure that we're all on the same page here.
Good
Count
afternoon,
one,
Martin.
sir, you're being charged with obtained property over $20,000 by fraud. That's count one. Count 2, 3, and 4, and 5 are all the same $10,000 bonds. That's misrepresentation of payroll or class workers to avoid diminishment. Count 6 is fraud, money laundering to transfer $100,000 or more, and that's 7 and 8 as well. Bond set at $100,000 each count. Count 9 is fraudulent money laundering transaction, $100,000 or more. And count 10 is criminal attempt to solicit or conspire a first-degree felony. Bond is set at
$50,000.
$50,000. Can you pull up my email?
So I think the total is $500,000 as it stands.
Yeah, I think I saw a case. I'm just trying to see about a Nebula requirement.
If you're referring to the case of the second DCA, it is not, there's a fourth DCA case that conflicts with it. So there's a fourth DCA case that says we can retain defendants in custody for the purposes of determining the Nebula requirement. It does conflict with the second, so ultimately it may go to the Supreme Court. But at this point, there's binding case law from the fourth.
Judge, I can.
Hold on a second.
Sure.
Let me ask you this. I'm not bound by the bond. I mean, this is coming to me de novo, correct?
Well, there is actual language in the arrest affidavit that the bail's only to be modified by the trial judge or the chief judge. In the previous case, again, we came to an agreement between the parties, and I think ultimately that will be the case in this particular case. However, I would object to any modifications at this point
Go ahead.
because the nature of the investigation against this particular defendant is that he was committing essentially an ongoing fraud over the course of a number of years. There was an a search warrant that was executed on the defendant's house. Between his home and some other safety deposit boxes, the police were able to seize over $300,000 in cash as a part of this scheme. So in regards to this particular defendant, as opposed to the last person, I do have concerns that he has access to significant funds of cash. Again, he has other assets that have not been, seized or tied to his criminal activity, and based on what the extent of those may be, we may in fact come to an agreement as to the bond and the Nebula and all those other conditions. But at this point, I believe it's a little premature to revisit those issues without the proper documentation, because essentially none has been provided at this point.
Is this his first appearance before a judge?
Yes.
Okay, so I can reset this for tomorrow morning or Friday. I would like to research a little bit more about this warrant to arrest and the language in there.
Okay, and Your Honor, like I said to defense counsel, I would prefer that this just be assigned to the regular division judge, seeing as how the co-defendant's already been magistrated. I don't want to separate them, and I don't want to delay, I guess, the process.
Judge, I don't have an objection to that, although with all candor, appreciate the court's position and the court's inquiry. Based on conversations with opposing counsel, I have no objection to sending this to what will ultimately be the home division.
Okay. All right, so the court will adopt all
Judge, and Martin, good afternoon. I don't know if you can see me. Okay.
Good afternoon.
We're in the process of an ongoing negotiation with the state, and I do need some documents with regards to the valuation of the home. Can you point me in the right direction to whom I should seek that from?
What do you mean by direction of the home?
You know what you can do?
Maybe.
I think Mr. Romero's gone. Does anybody know the phone number at the jail? Is there any deputies there? All right, deputy, what's the phone number over there?
It is.
Mr. Romero, how do we dial you?
Let's hold this. I'm looking at it right now. 7714.
Okay, sir, I'm going to allow you to talk to your attorney, but just let me conclude this hearing. So, court's going to keep all the bonds in place, adopt all conditions of the 226 warrant to arrest, and that's obviously without prejudice.
Passport is to be surrendered prior to release or after?
Okay.
Are you giving him the same?
This is what I'm doing. I'm magistrating him. I put on here, adopt all conditions of 22618 warrant to arrest without prejudice. Parties stipulate to address any bond issues or conditions before the division judge, and that's it. I believe I have the authority, but since they stipulated, and I am gonna look into it when there is a warrant, because my understanding is when there's a warrant and they haven't appeared before the judge, that this court, as a magistrate court, has the authority to change the terms and conditions. So, and I'm not contesting that today, I'm just letting you know in the future, and I am gonna look into it. Maybe I don't, maybe I do, but just so that you know from next time when you come. So I'm just leaving for this gentleman, Mr. Bolduc. I'm leaving it in place, all the terms and conditions, but for Darlene Engel, all Nebbia conditions have been satisfied. The defendant to surrender the passport to the clerk of the court on or before March 11th. Defendant's brother, Darren Griffin, to file affidavit with the clerk of the court on or before March 2nd, 2018 at 11 a.m.
This Engel will be released today if the bond is posted today.
Yes.
I just want that to be clear.
Defendant shall be released upon bond being posted.
Okay.
Yeah, that's Darlene, not him. Again, we're agreeing that she's going to have the same time frame to surrender the passport. So, if she
just
doesn't,
put here, I don't know how to make it any simpler.
Yeah.
I put, bond shall be released upon bond being posted. Defendant
he's not
shall be
posting anything
released.
right now
Hold
anyway.
on. This is what I put on here. Defendant shall be released upon bond being posted. That's it. Here you go. If you have a problem with the language and you need it changed, Okay, there you go. Thank you.
Yeah, she should be able to turn them both in.
Okay, and then I'll give you this one, Madam Clerk. Thank you. Anything else? You can go and call. He said it's 7714. All right, sir, you can go to that phone right there.
Okay.
Thank you very much.
Oh, over there, okay.
You can sit down right there. I'll put it on sidebar. Any other business for the court today? No other business, okay.